This morning, as I understand it, Mr. Chairman, we're going to consider 4 nominations, including Jeffrey Rosen, to be Deputy Attorney General. So let me focus my remarks on him. I had the pleasure of meeting with him. He's sitting there in the front row. We had a very pleasant conversation, and I want him to know that I very much appreciate that. He's been nominated to fill an important position within the department. The Deputy Attorney General is the second ranking official in the department and essentially leads the department's day-to-day operations. It is my understanding that key law enforcement and national security components report directly to the Deputy Attorney General. That includes the Criminal Division, the National Security Division, all U.S. attorneys, the FBI, the DEA, among others. The Deputy Attorney General also directly oversees the Solicitor General and the Office of Legal Counsel. In short, this is a position that carries tremendous responsibility within the department. Given the Deputy Attorney General's direct oversight of the department's law enforcement and national security components, it's critical that whomever holds this position values the independence of law enforcement. The next Attorney General must also be able to withstand political pressure on investigative and prosecutorial decisions. This ability to withstand pressure is even more important, I think this side believes, in light of President Trump's repeated calls to investigate his political rivals, including Hillary Clinton. The current Deputy Attorney General, Rod Rosenstein, had decades of prosecutorial experience before assuming this position. And with that experience, he had an understanding of the practices and precedents that help ensure the independence of law enforcement. My big concern is that because Mr. Rosen has never before served as a prosecutor, he may not have that same intimate knowledge of those practices and those precedents. Although several previous deputy AGs did not have prosecutorial experience before they were confirmed, but neither the Attorney General nor the current head of the Criminal Division has served as a federal, state, or local prosecutor. So my intention is to ask you, Mr. Rosen, about this background, how you intend to get up to speed on law enforcement matters, and how you will ensure the independence of law enforcement. My greatest concern, candidly, is independence from political importunings, and this nominee's ability to withstand that is a decisive point for me. Mr. Rosen has been nominated to be the second ranking official in the Justice Department with substantial influence over the day-to-day operations of all department components. In light of that, I find his past opposition to environmental regulations troubling. And let me just put this on the line so you can respond to them, Mr. Rosen. In your time working for President George Bush, it's my understanding that you sought to prevent the administration from regulating greenhouse gases, even though the Supreme Court had recognized that the Clean Air Act required the Environmental Protection Agency to undertake such regulation. That's Massachusetts versus the EPA in 2007. In addition, press reports suggest that you, Mr. Rosen, have been one of the chief authors of the Trump administration's plan to grant fuel economy or to gut fuel economy or CAFE standards. And this includes a challenge to California's right to set its own standards to combat pollution. It also presents a challenge to a bill that I authored, which set the parameters of how this is done, which has been the law, and I'd like to see continue. Given the Justice Department's role in defending the president's assault on fuel economy standards. It's important to understand what you, Mr. Rosen, what your views are, and your past work on this issue, and to hear specifically whether you will recuse yourself from any cases involving the administration's efforts in this area. I have concern about your work as Chief Legal Counsel to the Platform Committee of the 2012 Republican Convention, which, as I'm told, took extreme positions on issues including the Affordable Care Act, the Second Amendment, women's reproductive rights. And I hope to explore that with you. If I understand correctly, the 2012 Republican platform claimed that the Affordable Care Act was, quote, an attack on our Constitution, end quote. It also asserted that the 14th Amendment should be understood to restrict women's reproductive rights without any exceptions, including the life of the mother. And the platform argued that bans on assault weapons and limitations on the capacity of magazines or clips are unconstitutional. I hope you'll set that straight in your commentary. In addition, several years before your work on the 2012 platform, it's my understanding that you wrote an op-ed in which you claimed the Affordable Care Act was a government takeover of health care. That was Obama v. the regulators in the Washington Post on August 6, 2009. So these are troubling positions. They're made all the more troubling given this administration's hostility to women's health, common sense gun control measures, and the Affordable Care Act as a whole. The Justice Department's Civil Division argued in a March 25, 2019 filing that the entire Affordable Care Act, including its protections for those with pre-existing conditions, is unconstitutional. That's Texas versus the United States, and I'd hope you'd address that.